Thank you very much for everyone who's participating. My name is Maureen Reyes. I serve as Vice President of Business Development for AKAM. I'm very thrilled to bring this wonderful platform of education. I have Ryan with me, so we are going to be jumping in and talking about the legal updates. Now, what's important though is any questions that you have, there's a chat button in there. Send them our way. We want to leave the questions towards the end. This is a recording session when you logged in, and we will be sending out the recording and the outline. So, I just want you to listen in. Any immediate questions, let us know, and we will be happy to start the webinar in just now. Ryan, the floor is yours.
We're good. Okay. Hi, everybody. My name is Ryan Poliakoff. I'm with the law firm Poliakoff Backer. It's myself and I believe now 8 other highly experienced attorneys working at the firm, and a team of paralegals and assistants, of course. And we specialize in condominium, cooperative, homeowners association, and country club law. I'm a board certified expert in condominium and plan development law. This is my core practice. This is what I do. And we're going to be talking today about the legislative changes that became effective July 1st, 2025, particularly as they apply to condominiums. Now, before we jump into it, I want to first thank AKAM for bringing us all here and for putting on this presentation and inviting me to be here. I go way, way back with AKAM. I think maybe 15 years ago, I was actually the vice president of management for AKAM. And I really love what the company is doing these days. And so those of you who are working with AKAM, that's fantastic. And I have a lot of clients that do as well. Lots of great management companies out there too. But AKAM's doing a great job. And I thank them for having all of us here today. There's a lot that happened in the latest statute. And so some things I'm going to spend more time talking about, some things less. There are some little changes to the statute that I'm not including in my presentation that are not as interesting, but are more technical, dealing with turnover and things like that. As always, your best source of legal advice on your specific condominium, whether you're a manager or a board member, is going to be your own attorney. So I encourage you, after you've watched the presentation, to, if you have questions, we're going to allow for questions in the presentation. Next week, you're going to be getting a copy of the outline of this presentation. AKAM will be emailing that to everyone. It will have my contact information. You're welcome to email me questions if you don't have an attorney. If you just need a second opinion, you want me to clarify something, I look forward to hearing from you. If you need help and you're an association and you happen to not have counsel right now, of course, we're happy to talk to you about that too. So we will make sure to find a way, whether it's your own attorney or myself or someone else, or AKAM helping you out, to guide you all through this and some of these changes. And I will tell you in advance, some of these things, we don't know exactly how they're going to work until we see, because there's some weird wording in the new statute. And, we're
waiting for the department also to go ahead and give, those links to register. So absolutely, it's something that's going to be interesting, to see.
Right. And also there's rulemaking authority in the statute, where now the DBPR has to create rules. The Division of Condominiums, more accurately, has to create rules implementing some of these changes. So until we see those rules, we're kind of guessing, but I'm going to go through the highlights. Now, the 2 other things I'll say before I get started substantively, you're going to see me looking up from my screen. I have a giant outline on a computer monitor in front of me. So if I'm looking up, that's what I'm doing, is refreshing my recollection about what I want to talk about. And then also, for questions, I'm going to do my best, like I said, to leave time at the end. There's a lot to go through. We will try to get through some questions. I apologize if we don't get to every question, but again, you can email me. I will make sure to find a way to help you. So let's just jump right into it. Unless you think I'm forgetting something,
We're good. Let's
jump
go.
right in. It looks like a lot of us are here, so that's great. We're going to start with 718-111. Now, of course, 718 Condominium Act, that's where most of your laws regarding condominiums are going to be found. 718-111, generally speaking, is the section that deals with the association and operation of the association, not so much operation of meetings, which is 718-112. This is usually the more general stuff. Records inspections, insurance are found in there, some of those sorts of issues. First one. It has always been the case that in order to perform management tasks, you need to be a licensed community association manager. And the Florida statutes explain what those tasks are. Basically, anything substantive having to do with operating a community association, you need to be licensed. But that obligation, until recently, has always been on that obligation has always been on the manager, meaning the condominium did not have a specific obligation to hire a licensed manager. It was the person doing the work who was obligated to be licensed. And if they weren't licensed, they could be sanctioned by the DPR as an unlicensed person and be prevented from ever getting their license. Well, now that obligation has been put on the association as well. The statute says if an association contracts with a community association manager or management firm, the manager or management firm must be licensed, and all board members and officers have a duty to ensure that the manager or management company is licensed. Now, this is a pretty significant change because I know a lot of communities where they have hired people to be assistants or administrative people to help the board, and those people are not licensed. And the boards sometimes worry about it, sometimes don't. But now you should be aware, if you're a board member, that you have a specific statutory obligation to make sure that anyone who is doing management services is a manager. And I can tell you that is a licensed manager, I should say. And I can tell you that if your assistant, your person in your office is doing more than basically taking notes and answering the phones, they're probably falling within the licensed manager category. So this is very important and substantive and something to be aware of. If a manager or a management company is suspended, that allows the condominium to terminate them effective that date, presumably regardless of what the contract might otherwise say. Okay, minutes. The statute now expressly says that condominiums must maintain minutes of committee meetings. I believe that was always the case. I believe you should always have minutes of committee meetings, but that was never explicitly stated. Now it is. You are also now explicitly required to keep recordings of any meeting held by video conference for at least a year after the date the video recording is posted. This is an interesting and important change. And we're going to talk about this a little bit more when we talk about the new rules concerning video meetings, because they complicated things significantly. But you should be aware that you're now going to have to either keep recordings of those meetings, and you'll see on the requirements, you either have to post a hyperlink to it or you have to post the meeting itself. We'll talk about that in a little bit. Bank statements and ledgers are now explicitly official records. They were always official records because remember, the Condominium Act has a catch-all which says any documents related to the operation of the condominium which are not otherwise expressly stated. So I think in any world, bank statements and ledgers were always official records, but now they've been included in that official list. There's another change which is worth noting, that official records that you have to post on the association website must now be posted within 30 days after they are received or created. I will tell you, I can see some questions are coming in. That's great. I'm going to address all questions at the end because I want to make sure I get through the bulk of the material, not ignoring any of you, and thank you for submitting your questions. Keep doing so. But we're going to get to those things at the end. I know this is a little bit of an unusual format, doing this kind of silent web seminar, but we're trying to get the most information we can to the most people. Posting on the association website, a few new things have been added for posting on the association website. The approved minutes of all board meetings for the past 12 months must be posted. And as I said, a video or hyperlink to a video recording for all meetings conducted by video conference over the past 12 months. It's another new requirement. And also a copy of any affidavit required by 718. So for example, an affidavit of mailing, which is very common in the industry, an affidavit of mailing the meeting notices, the budget notice, all of those things, those affidavits now have to be put on your website. I know with my clients, a lot of them put way more on their website than is required, which is actually a good practice because the statute since last year says that when you get a record inspection request, you have the right to simply direct people to your website and say, that's where you can inspect these records. So I encourage that. But in terms of what the statute expressly says, it's a different story. And again, I'm going to slow down a little on the really crazy substantive stuff, SIRS, video recordings we're going to talk about in a bit. I'm going to blow through some of the faster stuff to make sure that we get to some questions at the end. Annual audit, another thing that we find in 718-111. First change, the association now has 180 days after the end of the fiscal year to deliver end-of-year financials. That's an increase in time. So that is good for condominium associations. Now, I will say, in my experience, a lot of condominium, hang on one second while I put all my devices on Do Not Disturb. Okay. In my experience, a lot of associations are missing these deadlines by months and months and months. It has become very difficult to coordinate between condominiums and their accountants. And I've seen a lot of accounting firms that are just way behind. So I know you all are having these problems, but I also know that the division has fined people for being late, even when it was not their fault. I have used the argument before with the division and been successful from time to time when I've pointed out that a condominium acted diligently to try to get their audit done, but it was the accounting firm that they kept begging to get the audit done, and the accounting firm kept delaying and delaying and delaying. So that is possibly a defense you could use with the division, but fines can be very significant, and this is a problem that comes up. So this extension is great, but you do have to be very diligent with respect to your end-of-year financials and any financial report that you may need to do. Owners can now request to receive end-of-year financials by mail or hand delivery, but also electronically via the internet. That's probably good for condominiums and makes your life easier. It now takes a majority of all the owners to vote to approve a lesser type of financial review. That used to be a majority of the quorum. Now, I recommend that my clients never go for a lesser level of review anyway. That is my general recommendation. The difference in price between a review and an audit or a compilation and a review, for example, is not substantive enough. If you are otherwise required to do an audit because of the size of your budget, to me, once you're in that range, it's not substantive to save $1,000 or $2,000 and avoid the benefits of having an audit. So I do always recommend that. They have made it harder to vote for a lower level of review. And now this is the last change that I'm going to talk about to 718-111. This is another unusual one. The question has always come up in my practice: what may community associations do with the money they have in terms of investing it? Where can they invest their operating funds? Where can they invest other association funds, reserve funds, or whatever it must be? There is now language in the Condominium Act that says boards must do their best to make good investment decisions to maximize returns on invested funds. And it says that reserve funds may be invested in CDs or bank accounts. So for reserve funds, we know that those are somewhat limited to the safe investment options. But what does that mean for other funds? Does that mean that if you have other accounts, you can now invest those monies in stocks or bonds or mutual funds? And when the statute says that you have to make good investment decisions to maximize returns, that the statute doesn't talk about balancing that with safety of funds. Do you now have some kind of obligation to maximize returns even if you're not comfortable with the risk? This is kind of unusual language, and I'm not really sure what the idea here was. I will tell you that if I am giving advice to my clients, it will remain the same. And my advice will continue to be, don't put your money in anything where you could lose the money. Basically, that means CDs, bank accounts, government like treasury bonds, municipal funds, money markets, potentially, depending on the guarantees involved, mutual funds where they invest only in risk-free investments. I really don't feel comfortable with the idea of a board investing common funds in something that could lose that money, regardless of this new language in the statute. So this is something it is substantive. It is an interesting change. You really need to talk about this with your own attorney. It certainly opens the door to the idea of investing these funds more broadly. Personally, I still think it's a bad idea.
And Ryan, let me chime in there, because that's important too. Again, absolutely get with your experts, get with your management team, your auditor, your attorney, because when you think you have all these funds, right, and you're like, okay, let's make money, and no, because you might have some capital projects that are coming up, and you will need those funds to retain them. And again, you have to make sure if you're going to invest, it has to be wisely and understand exactly the funds that cannot be restricted, etc. So before going into any contracts, anything, involve your association legal counsel. Obviously, your management team is here to serve you and provide you all the information that you need. But don't just because the statute changed somewhat, like be responsible, be a responsible board, be a responsible manager, get all your experts involved before really like making that decision. Okay, that's important. That's just my 3 cents.
I agree entirely. And I mean, just think about it for a moment. If you were to use association funds and invest them in something risky, corporate bond, whatever it would be, and you lose all that money, $500,000 you invested because you thought you could, save everyone money. Can you imagine as a board member having to go back to your owners and saying, look, I know we collected $500,000 extra for surplus funds, but we lost it all. We're going to need to specially assess you all. Regardless of this language in the statute, you don't want that. So absolutely look to your management company and speak with your attorney. Now let's jump to 718.112. As I said, 718.112 is the portion of the statute that typically deals with operations of actual board meetings, membership meetings, those sorts of things, how you operate all these things. The statute now expressly says that board and membership meetings can be conducted either in person or by video conference. Now, since COVID, a lot of condominium associations have gone to Zoom meetings in one form or another. And there was always a little bit of an open question as to whether that was okay. The reason it was an open question is because while we know under the statute, board members can participate in meetings virtually because the statute says so, they never said that the meeting can be held virtually or that owners can participate virtually. We just always kind of assumed because why not? In the last 2 years, there has been a couple of arbitration decisions where an arbitrator with the DBPR, the Division of Condominiums, expressly said that you must have a physical location for a meeting, even if you're doing it by Zoom. This was what the arbitrator had said. And so my advice to my clients for the last couple of years has been, if you're going to do video meetings, you should at least have a physical location somewhere where people can attend if they don't want to be on Zoom. Some have followed that advice. and some have not. Now, arbitration is not law per se. It only binds the two parties in the arbitration. It's not precedent. Future arbitrators aren't required to follow it. Courts aren't required to follow it. So we never really had a mandate, but now we do. We have a mandate now. The division has said expressly, you can do video meetings, but you have to have certain requirements if you do. So here are the requirements. If you are conducting a meeting, and this includes, by the way, membership and board meetings can both be virtual. The notice must say that the meeting is being conducted virtually. The notice must include a hyperlink and a conference telephone number that allows owners to attend via telephone. Now, I want to talk about that this is weird. By definition, a hyperlink is a clickable link. That's what a hyperlink is. So I don't know, frankly, that they really intended to use the word hyperlink. I think this is a case of the people writing the law using a term that they thought meant something and maybe means something different than they thought. What is the point of putting a clickable link in a piece of paper that you're posting on a bulletin board? Say you're doing a regular board meeting, 48 hours notice, you're posting it on the bulletin board. Yeah, you have to post it to the website too. And so I guess, a hyperlink might be valuable there, but for anyone seeing the notice on the bulletin board, are they really going to sit there typing out, XBCWQRW/? I mean, that's what these Zoom hyperlinks look like. It makes no sense to me. What I think they should have said is must include instructions for logging into the meeting over the internet. That's really, because for Zoom, all you need is a meeting ID and a password. And for my personal meeting notices, up until this point, that's always been what I included, just a meeting ID and password, because the hyperlink didn't do anything when you're posting it on a bulletin board. But now the statute uses the word hyperlink. So starting July 1st, that's what you have to have. I think they should adjust that. They may never, but in any event, that's what it says. You must have a physical location where owners can attend the meeting in person. This is now mandatory. So where we always had this question, does there need to be a physical location? Yes, there needs to be a physical location. And the meeting must be recorded. And as we said, with respect to 718-111, that recording must be maintained as an official record. Now, here's a couple of interesting substantive things for membership meetings. First, if you are holding a membership meeting via video conference, members may vote electronically. Now, your condominium may never have implemented electronic voting. So what does this mean? We're going to get to this a little later in the presentation, because this is one of the crazier things that they added to the new statute, a new system for voting electronically when the association has not implemented electronic voting. But I will give you the preview and tell you my advice to every condominium in the state today is implement electronic voting as soon as possible with an electronic voting company. I don't know who came up with these rules we're going to talk about a little later on. Maybe it was lobbying by electronic voting companies. If it was a pretty clever idea of theirs. But you don't want to leave things to the new statutory procedure. We will discuss that. You want to implement electronic voting. They've made it easier. You don't have to do 14 days notice anymore. They got that out of the statute. You do have a certain type of resolution you need to pass with certain information. Your attorney can easily help you prepare that resolution. The first step when implementing electronic voting is always to find the voting company, because the things in the resolution go to the voting company. That they require information from the voting company about opting in, opting out, who the voting company is. So that's your first step. Go to your management company. Let them help you find a voting company. There's 4 or 5 really good ones out there. Once they've helped you find an electronic voting company, go to your attorney, have them prepare the resolution, implement electronic voting now, before your next membership meeting. That is my advice. Here's another really weird one. This one I have a huge problem with. The statute now says that if the virtual meeting is the annual meeting A quorum of board members must be physically present at the physical location, right? Remember, if you're going to have a meeting, you can have a virtual, you must have a physical location. If it's the annual meeting, a quorum of board members must be physically present at that physical location. Now, why do I have a problem with this? First of all, this is a membership meeting. I know people get confused about this because I always see annual meetings where the entire board goes and they sit at the front of the room and they hold court like it's a board meeting. Membership meetings are not board meetings. Board members at a membership meeting are, their only purpose is to be there is as members. You know, there are slight exceptions, meaning the president is often the chairperson of the meeting, so they would have a role in the meeting. But the board members themselves, whether they're on the board or sitting for re-election or anything else, there is no legal reason for them to even attend the membership meeting. They could attend by proxy and it's 100% legal. So now all of a sudden we're statutorily requiring these people not only to attend the annual meeting, but to be there physically present in person at the meeting. Doesn't make legal sense. It was written by someone who was not thinking about the corporate aspects of this. I don't understand what they were trying to accomplish with this. Maybe it will be changed in the future. Now, here's the second part of it. What happens if you notice a virtual annual meeting and you know that for it to be a legal virtual annual meeting, a quorum of board members must be physically present, and they just don't show up? So, okay, presumably that means the annual meeting doesn't happen. Now, you know, in a condominium, the election doesn't require the annual meeting to happen. So I am presuming, even if this were the case, that the election would go forward. But for example, there's this new electronic voting procedure where, as we'll discuss later, people can just email in votes to an email address that are not secret votes. If the meeting itself doesn't occur because the board members aren't present at the meeting, does that invalidate those votes? Do you count those votes? Do you only count votes that were submitted via other means? I don't know. It really complicates things to a point that I think they weren't thinking through. And this is something that we as lawyers are going to puzzle through over the next year. But again, yet another reason to implement electronic voting. To me, that's like one of the big priorities, right?
And Ryan, I want to, highlight again the takeaways on this specific topic. We need to understand the landscaping has changed. For the managers, for the ownership or membership that it has changed. So we need to always get with your legal counsel to make sure, like, when you're passing that electronic voting, do it correctly, make sure the minutes are correct. So that way it facilitates, right? There's a good question here. And again, and I want to say it out loud, what is the difference between a board meeting and a membership meeting? And, it's important because right now there's loans that you're going to be taking and etc. So go ahead, and Ryan, and just give that, differentiate.
Sure. Yeah. So that's a good question. So remember, your condominium is made up of owners and units, and every single unit has a vote associated with. And the members of the condominium at large, which is basically every unit, all the owners are members, but each unit only has one vote. The members of a condominium at large vote on certain business issues of the condominium. For example, the members are the ones who elected the board of directors. The members are the ones who typically must approve material alterations. The members are the ones who typically must approve amendments to the governing documents. Members vote
loans
on certain well, some, not always. I mean, a lot of condominium boards have the right to take out loans without a member vote. So that's it depends. There are certain things that require it, and it depends on your governing documents. Members vote at membership meetings. That is when you call a meeting and you gather all the members together, either in person or by proxy, and you ask them to vote on membership issues. Board members, who are the elected representatives, just like you elect congresspersons, your board members are your elected representatives. They are the ones responsible for overall policy and direction of the association and for the vast majority of decision making. And their decisions are made at board meetings. At a board meeting, you only need a quorum of the board members to attend and conduct business. At a membership meeting, a totally different type of meeting, you need a quorum of the members, the units, to vote. Go ahead.
No, sorry, sorry.
I thought you raised your hand.
You're perfectly fine. I'm sorry.
Yeah. So that is the basic difference. I don't want to take too much time on that because we're a half hour in, and I'm doing, it's so much material. And as I said, some of this stuff I'm going to have to blow through to get through it in an hour. Let's talk budgeting real quickly. You may be aware there used to be a procedure where if your budget was more than 115% of the prior year's budget, members in the condominium could, by petition, present a substitute budget for the members to vote on. Well, now the Condominium Act has changed, and they've said that if you have a budget, if you are going to propose a budget that's more than 115% of the prior year's budget, you must simultaneously propose a substitute budget that does not include any quote unquote discretionary expenditures that are not required to be in the budget. Now, what does that mean? Discretionary? I don't know. Is valet discretionary? Is security discretionary? Most condominium budgets I know don't really have discretionary spending. I have really no idea what this means, but this is what the statute says. You have to propose this budget at the beginning of your budget meeting, and owners must consider and may adopt this substitute budget at the budget meeting. Now, here's a big hole in this. A budget meeting is a board meeting. It's not a membership meeting. How are members possibly going to vote on the substitute budget at the budget meeting? The statute doesn't say you must simultaneously call a membership meeting for the purpose of voting on the substitute budget. It says members may vote at the board meeting. You won't have sent out a proxy. You won't have noticed a membership meeting. This is another one of those where it was written by people, well-meaning, I'm sure, but they heard there was a problem. They wanted to try to solve it. They're not well-versed in corporate procedure. And so we have now this weird thing where you're going to have to deal with your lawyer if you have a budget you're proposing that's over 115% to figure out what to do. What I think you're going to do is you're going to do exactly what the statute says. There's not going to be a way for members to vote at the budget meeting. So the vote's going to fail and you're going to go forward with your budget. And this is going to be completely non-substantive, which is not what the legislators intended, but that's how they wrote it. So that's how it's going to be. Let's talk about reserves. It used to be that reserves were certain specifically delineated items like pavement and roofs, and then anything that was over $10,000 that was deferred maintenance. Now that number has been raised to $25,000, and it can be adjusted by the division annually based on inflation. So they've reduced a little bit what you need to put in your reserve study. The big issue over the last few years has been the structural integrity reserves. The SIRS, the Structural Integrity Reserve Study, everyone is obligated to get. And when you get your SIRS, you're required to put away reserves for the structure of the building. And starting with the budget for next year, those reserves can no longer be waived by the membership. Now, a couple of interesting changes there. The deadline for performing your SIRS reserve was extended to December 31st, 2025. It was previously December 31st, 2024. Now we're halfway through 2025. I can't imagine there's a lot of condominiums out there that didn't get their SIRS done last year. So I don't know who this really affects. I don't know what this means for condominiums that aren't collecting SIRS this year because they didn't get their SIRS study done. This seems like it kind of excuses them from collecting reserves. So now we have condominiums that did the right thing, got their SERS done, and are collecting SERS this year that maybe technically didn't have to. Nothing we can do about that. This is
Right, yeah, I would say I did a webinar earlier this year specifically on reserves and the SERS, right? I have found that our tri-county condominiums are great students. They're A+ students because most of them have reported it to the state, like they're doing the right things, right?
I don't know a single client of mine.
Yeah, and when we transition in, again, these are critical questions for AKAM when we start servicing a client, is that like, did you do your reserve studies? In some cases, we've seen that they haven't, but we quickly like bring them up to speed. So I think Maureen, this is like not the Tri-County, not the Palm Beach, the Broward or Miami-Dade folks. I think it's more of like the skirts of Florida that they're not being, A students based on the webinar that I did earlier this year. But I think it's here, like our condominiums are in that day in and day out.
Right. Now, SERS, of course, are assessments you're supposed to be collecting. The statute now says that you can fund your SERS with regular assessments, special assessment, lines of credits, or loans, but it says that a special assessment, line of credit, or loan requires the approval of a majority of the total voting interest of the association. Now, this seems to be the case even if the board has the power to borrow money or pass special assessments without membership approval. So it almost seems as if the division intends for SERS to be funded by assessments unless the membership approves alternate methods. Now, I understand for a loan, but I don't get why that would be the case for a special assessment. I have lots of clients that pass special assessments to fund their reserves, and most of them didn't need membership approval to do that. The boards can fund special assessments themselves. Does this now mean that that's no longer an option unless the membership approves the special assessment? It's written that way. I don't know what the idea behind it is. This is another unintended consequence. I don't think that this was what was intended when they wrote this, but that's now what it says. You also now can secure a line of credit or loan to fund the expenses required by either a milestone inspection or a SERS. And that line of credit or loan must be sufficient to fund the cumulative amount of any previously waived or unfunded portions of the reserve funding amount. And that funding must be immediately available. It's not clear to me whether this paragraph supersedes what might be owners' right to approve loans or borrowing if they have that right. That's another kind of open question under the new laws. Again, this has to do with funding the repairs themselves, not funding the reserves for collecting them in the future. For a budget adopted on or before December 31st, 2028, if the association has completed a milestone inspection within the previous 2 calendar years, the board may, upon approval of a majority of all voting interests, temporarily pause for no more than 2 consecutive annual budgets, reserve fund contributions or partially reduced contributions for the purpose of funding milestone repairs. Now, I get a lot of questions about this because a lot of people saw this and thought this meant you can now get a membership vote to pause reserves, period. But that's not what the statute says. It only says you can do this to the extent the funds are being used for current existing repairs. This is not a right to just pause collecting your SERS or your reserves. This is a right to, if you are going to contribute $500,000 to your SERS, this is a right upon a membership vote to use that money to repairs and to not put it in your reserves. It basically allows you to collect less money when you are actively making repairs. Now, what happens if you've already spent the money to make your repairs? I don't know. Again, this is what the statute says. They didn't really deal with that. If you do this, you have to have a new SERS study performed before you restart your SERS contributions. And I'm not exactly sure what happens if you've already assessed for the money you need for the milestone repairs. Can you still say, well, we assessed an additional 500,000, but now we're going to use the we're going to call that CSRS money, and we're not going to collect the CSRS anymore. I don't know.
And you're absolutely right, Ryan. There's a lot of questions specifically about the CSRS and the milestones and what we collect and what we should, and absolutely work with your management team, work with your attorney, and work with your accounting team and your capital. If you're going through a capital project, like all that information, all these entities need to come together for the betterment of the community. I mean, you don't isolate your attorney, don't isolate, that's very important, because you can't think, oh, now we're going to fund less and we're not going to put money in and that's it. No.
Now, in my outline, we only have 20 minutes left. In my outline, I have a few other things about this. Review it, review the statute. I'm going to jump around a little bit because, again, I want to leave at least 10 minutes for questions at the end. I want to jump to electronic voting because this is really, really important. So we all know the statute provides a method for electronic voting secretly, in elections. Not regular membership votes are not secret, but in elections, it provided a means for confidential voting, anonymous voting that goes hand in hand with the 2-ballot envelope election procedure, right? Which the whole point of it was implemented to prevent fraud. So they've now adjusted that a little bit. What they've said is that, first of all, the meeting notice where you implement electronic voting now no longer needs to be sent 14 days in advance. That's good. Makes it easier. You still need the resolution, but it simplifies the procedure a little bit. It also says now that at least 25% of the voting interest of a condo may petition the board to adopt an electronic voting resolution, in which case the board needs to go ahead and do so. This is the important part. If an association does not use electronic voting, anytime you have a membership meeting, you have to designate an email address for the purpose of receiving electronically transmitted voting ballots. Okay, this is even in an election, this appears to be the case. An electronically transmitted ballot must include a space for the unit owner to type in their unit number, so it's not confidential or private, a space to type in his or her first and last name, which also counts as a signature. So it's not going to be signed. They're just typing their name. A specific statement in bold letters recognizing that they are waiving ballot secrecy. And that ballot must be received no later than the date and time of the meeting. And the association needs to check that email address to collect any of those ballots. Now, my concern about this and why I'm telling my clients, my advice, and I'm going to write this in my column too, I think next week, you have to implement electronic voting, because what this means is that, look, I know certain types of fraud are crimes, but we also know it goes on. What is preventing someone who knows who in their building are voting a certain way? They know what the clicks are, right? So all they need to do is set up fake Google email addresses. And remember, you don't need to sign these electronic ballots. You just need to write in the name of the unit owner, the unit number, you type the name, have the statements, and you email it in. What's to prevent someone from emailing in ballots for any person in the building that they think is going to vote a certain way that they don't like? Either they will end up voting for all of those people, and you have no way to verify. No condominium, practically speaking, can verify whether an email they receive is from someone's real email address. If someone goes out there and creates Ryan Poliakoff 6013@gmail.com and emails someone, that person can't realistically just go to Google and say, hey, Google, who is the person who signed up for this account? It would require all sorts of complicated coordination with Google. It's just not going to happen. So what's going to happen here? What happens if a condominium receives all of these electronic ballots and people have voted by mail as well, right? Because you don't have electronic voting in these situations. So you have a mail-in ballot in an election and you have one of these electronic ballots. Do you reject them both? Is this a way for someone to invalidate someone's ballot by sending in a fake electronic ballot? Is this a way for someone to vote for someone illegally? The statute was written with fraud protections for elections, a double ballot system with elaborate procedures for opening them to make sure they're always anonymous. They've done a very good job of preventing fraud. I rarely see election fraud. It's very hard to do under this system. Electronically, it's a little easier to do, but still pretty well controlled. This to me, I'm worried this is going to create a mess. And so you need to be aware of this. And again, simple solution: before your next membership meeting, implement electronic voting. You avoid all of this. Does it cost a little bit of money? Yes. Is it a good usable procedure too? Yes. Does it make your elections faster? Much. Does it make it easier to solicit votes? Yes. I encourage electronic voting anyway, but whereas it was just optional before, and I appreciate there's a lot of condominiums with older persons that maybe aren't as tech savvy, implement it anyway, because it will prevent this system, which I'm not, on initial read, I'm not a big fan of. It will prevent this from being.
And again, the best practices, as the landscaping of our industry has changed dramatically over the past few years, I think now more and more the ownership are very comfortable in, reading electronically, putting the votes in. Again, if you have a capital project or you have like a change in your condominium that you want to, do a material change, you have to get these votes, right? And you want to bring value to the community. So absolutely, I am in agreement. AKAM, like definitely, we always, want to do electronic voting and those meetings also are very practical. You're done within maybe an hour or two instead of having a 5-6 hour meeting in the elections, right? So, I
love electronic. It saves you money. You think about.
I know at the end it saves you money
your
too.
Your lawyer will be at your meeting less time. You save for your meeting, you just save $300-400 right there. So or more for some lawyers. I'm more reasonable than that, but not everyone. So it can be a big deal. One more thing I want to touch on before questions. This is really, really important, and it goes to managers. I know we have some managers listening in, maybe a lot.
Yep.
Under the new licensing law, and I'm skipping some stuff. Again, please read my outline. I'm doing my best. A CAM may not knowingly perform any act directed by an association if that act violates any state or federal law. That this to me is just, I feel so terrible for managers, honestly, because I'll give you an example. Someone makes a written request to inspect records. It's one of the troublemakers in the condominium. They make a written request to inspect records every 2 weeks. It's eating up the manager's time. The board says to the manager, don't respond to her. We're not giving her these records. She's a pain. Don't respond to her. We'll deal with it. Don't respond to her. What does the manager do? Your board, your boss, the person who decides if you have a job, has just directed you to do something that violates the Condominium Act. The licensing statute now says you absolutely may not do that. If it violates the act, you can't do that. So you are now, as a manager, obligated to tell your board, I'm sorry, I am prohibited by state law from ignoring the Condominium Act. We must respond to this person. With some boards, that's going to create a lot of tension. Does this mean that the division is going to start sanctioning or suspending managers if they followed the direct instructions of their board not to do something that the statute says you're obligated to do? If you're obligated to provide a meeting notice on 48 hours and the board comes to you and says, we know it's not 48 hours, it's only 36 hours, but post it anyway, do you do it? This is going to be a mess to me. And I feel terrible for you as managers that you have to deal with this. And I know AKAM is going to jump in and help you all navigate this. I'm certain.
Absolutely right. But here's the thing though. What's important, because always you have to look at the solution, right? That's why it's so critical. When you mentioned this earlier, is to have a website. The portal of your condominium, you should have all your contracts in there, everything that the statute, ask you to do. Because when those records requests come in, they're probably seeking, oh, I want to see the financials, I want to see an audit, I want to see the contracts. You have it in the website, it shouldn't be an issue, right? It shouldn't be an issue where your license is put in risk. However, that I think best practice is, again, redirecting and making sure your website is up to, and doing the best practice, make sure your website is up to statute. And when this homeowner asks these questions, they're going to be in the website. So I think
Right.
it's critical to always just think that way.
Let me blow through some questions because a
Go for
lot
it.
of these are going to be quick and
Yes.
easy. So let's burn through
Go.
them. From Gabriel, does the requirement for minutes apply to ad hoc committees or just standing committees? All committees. The statute doesn't distinguish between the two. Committee is a committee. The board establishes a committee. It meets. You're required to follow the board meeting rules unless your governing documents say otherwise, and the requirements for the minutes would apply no matter what. Does X board president, does an ex board president whose advice is respected, if charging a fee in the future to the board for advice, do they need to be licensed? The short answer is the statute lists what constitutes performing management services. If a board member, if any person, including an ex-board member, charges for that, they must be licensed. If they don't, they're not. It comes down to the remuneration, the payment. If they are just giving you their opinion and advice, if they're a assistant to the board, they're not charging for their services, you don't have an issue. If they're charging for what they're doing, giving certain types of advice probably doesn't fall within the prescriptions within the AKAM statute, but a lot of things do. Helping to prepare budgets, helping to prepare documents, all of those things do. So you really need to look at that statute. Paul Sands mentions that a clickable hyperlink works in an email or a PDF or the documents on the website, 100%. And I admitted to that when I said it. I just still think that given that paper notices is still the primary way of providing notice and the way most people in a condominium get notice, I think that hyperlink, I don't think they meant hyperlink as in the true technical sense of a clickable link. I think what they meant was it must include a way to log into the meeting. And they used the word hyperlink. I suspect that was the case. But in any event, we have what we have. The distinction between board and membership meeting we talked about. If a line of credit is being used to meet surge funding requirements, do you have to draw down the line of credit to fund the reserves or just have it available? So that's a really good question. I want to go back and look at exactly how that was written. And I don't know that I can answer it because I'm not sure. It says that the line of credit to fund the expenses required by a SERS must be immediately available for access by the board. But it doesn't say for the SERS itself. So I'm not really sure. That's something to talk to your attorney about, and it may be something that the division clarifies for us. But also, I'll take another look at the statute and see if I can puzzle that out. It is a good question. On the emailed ballots, couldn't the association simply require they be signed even though that's not required by statute? No, the statute says type the name and the name counts as a signature. That's what the statute says. So no, I don't think that you could require they be signed. That would go directly against the what's allowed by the statute. I think the better option is to implement electronic voting. What if the governing documents allow nominations from the floor? How can you perform electronic voting? Wow, it's a really good question, Bonnie. This has become so complicated because here's the thing. Remember, we're talking condos. HOAs, totally different story.
Yep.
Condos have a statutorily required procedure that allows for nominations in advance and does not account for nominations on the floor. The real question is, if your governing documents say that nominations can be made from the floor at the annual meeting, do you ignore that and follow the statutory procedure, which is what 99.99% of condominiums do? Or do you now have to somehow implement the requirements of your governing documents as well? Now, there's a arbitration decision out there which has thrown everything into a loop, where an arbitrator suggested that some requirements of elections are substantive and cannot be retroactively impaired by the statutory election procedure. And that the statutory election, forever, for 20 years, attorneys have assumed that you go by the statute. The statutory election procedure controls. You go by the statute. Nominations from the floor, you don't do it because the statute doesn't allow it, you go by the statute. It's a really good question. I would still advise my clients to go by the statute. I think that arbitration case is an outlier, and it didn't make a lot of sense to me. Until a court chimes in, we're not really going to know how it's going to play out. Most attorneys I know still advise just going by the statute, but it's a gray area, and you really need to get the full options from your lawyer to talk about how to navigate your own individual condominiums requirements along with the obligations of the statute. How does an email vote versus a paper proxy work? Excellent question. You know, and this is another good point. A proxy is a piece of paper that allows someone to participate in a meeting in your place. Technically speaking, a proxy could be used to allow someone to participate in a board meeting for a board member, except the statute expressly prohibits that. So as a matter of corporate procedure, it's the same thing. The statute just says board members can't vote by proxy, but in a membership meeting, you're expressly allowed to vote by proxy. And proxies have all sorts of requirements. They have to be signed, dated, to be properly executed, in my opinion, at least. There's a form specified by the division. But in electronic voting, what they say in the electronic voting statute is that an electronic vote counts as participation in the meeting. So it would seem that this new email vote system replaces proxy voting, I guess, in a much less complicated way and without all of the protections imposed by proxy voting. It's crazy to me. It's a very good point. They overlap with each other. Again, the people writing these laws are typically not lawyers versed in condominium law. And this section in particular just doesn't work the way they think it's going to work. We're going to see a lot about this, I think, in the upcoming year. Someone said, would this apply if the board agrees to do work without a permit? That's a great question, because I think what you're asking me is where the statute says that a CAM cannot do anything, any act directed by the association if it violates state or federal law, and the board says, get this done without a permit, and state law requires a permit, or, I think that's a problem. I absolutely agree with you. I think that's a great point that you brought up there. I hadn't even really thought about it, but yeah, I think that would be a problem. I think this is going to, like, on the one hand, this kind of protects board members. This kind of protects managers, because a lot in the past, the manager didn't have a lot of juice to say, no, I'm not doing that. If a board instructs you to do something that is illegal, they're your board, they're your bosses, what are you going to do? And you lean back and you say, my boss told me to do it. Now you can't do that. But now you also have the ability to say to your board, I am expressly prohibited by law from doing that. I can lose my license. I am hopeful that boards are understanding and that the boards say, I get it. That's a shame. Do what you got to do. I don't know that that's going to be the case 100% of the time.
Yeah, but Brian, I have found when you're in the field, most of these critical questions, you always have your association legal involved, because you want to make sure, you dot your I's and, cross the T's, or whatever the saying is. But you always have, in those difficult questions, you always get your legal team involved.
Sure. And someone asked, by the way, at the end of the last question was, why is it a mess to require a CAM to follow the law? The reason we hire a management company is to comply with the law, even if the board chooses not to. I understand what you're saying from an owner perspective, from a person living in a condo. You want your board to follow the law. I totally get it. But it puts manager, I'm looking at it from the perspective of an employee. Think of yourself as an employee and your boss comes to you and says, do X, right? It puts you in a very awkward position. These are people who have to feed their families. I'm being sympathetic to managers. These are people that don't want to get fired. If you have an out of control board that does whatever it wants to do, while I think it is good that managers have to follow the law, I'm not saying managers should be allowed to break the law. I'm saying it puts managers in an awkward position when their bosses are giving them a direct instruction to do something and they have to say to their boss, no, I won't do that. These boards may fire the management company as a result. They could fire the manager as a result. These managers are providing for their families. It's tough out there. I'm being sympathetic to the managers. I hear exactly what you're saying. I worry about everyday well-meaning people who are just trying to provide for themselves and their families and are getting direct instructions from boards. Look, this whole doing work without a permit thing, it happens all the time. It's rampant, and it was a great example. And, you know, there are owners in a building who, just like you, will say, if you require a permit, get a permit. It's crazy. Why wouldn't you get the permit? But I'll tell you what, there's a huge amount of owners in that same building that'll say, everyone does this work without a permit. I redid my unit without a permit. Nothing bad happened. The work was still done by a licensed contractor. It's just a money-making venture for the county. It's going to cost us an extra $40,000 for the permit on this project. So it puts the manager in an awkward position. Last question. Our board refuses to provide all financials to owners. I know we're a couple minutes over. I'm just going to give a quick answer. Can you be specific in what financials must be posted? Remember, there's a difference between a request to inspect records and what must be on the website. Generally speaking, what must be on the website is the annual audit and there's a particular type of financial statement. I'm forgetting exactly what it said. If considered by the board at monthly meetings, must be posted too. General other financials like balance sheets, bank reconciliations, ledgers, those are inspectable on written request. Those are still inspectable on written request. Your board has to provide those to owners or they're going to get tagged by the division. But the ledger doesn't need to be posted to the website. So that's something you should go over with your attorney.
Yeah, it's practical. You have your short version, Ryan, which is your balance sheet, income, and all the supporting documents. Again, through an inspection request, you could go ahead and provide. It's normally 170 plus pages. But yes, owners have absolutely the right to see everything in that sense.
Two other really quick ones. Someone asked if some of these changes relate only to condos that are 3 stories or higher. If they relate to SERS and Milestone, where it was already 3 stories or higher, those changes are still 3 stories and higher. They didn't require SERS for shorter buildings. They just changed the requirements that were already there for the higher buildings. So if you're in low-rise buildings, you're still in good shape. And finally, someone noted, oh God, there's still more coming in. A thank you, my pleasure.
Yeah, but some of them are thank you notes, so.
Yeah, right. The manager's not supposed to put in writing. Yeah, you're talking about like a manager that got fired because they refused to break the law would have a very nice payout after they got sued. Maybe, maybe not. I mean, look, you know, Florida's an at-will employment state. You can, as long as it's not discriminatory, you can fire someone. That's not against the law. So I don't know about that, but point well taken. There's a lot of things in the statute that worry me. I'm very grateful for everyone who chimed in. I think I hit a lot of the questions, so that was good. Again, you're going to get my presentation. I want to clean up a couple of typos I noticed while I was reading it right here. My email's on the bottom. Email me. I'd love to hear. Even if you have another attorney, I'd love to hear from you. I'm not particular about those things. Obviously, I can't give you very specific advice about your condo, and your attorney is always the best person to talk to. But you don't have an attorney, I'd love to work with you. I'd love to talk to you. If you need a second opinion on something, we can do that too. It was my pleasure being here. A huge thank you again to AKAM. Love you guys. I've loved working with you over the last few years. You guys are doing a fantastic job. So thank you, thank you, thank you.
Thank you, Ryan, and thank you for allowing us to bring you on board and doing, I love to communicate, the education and pristine what we bring to the table. I think it's always important, to help support the boards, the ownership, our team members. So again, thank you for your time. Like Ryan says, we will circulate the outline. We'll give you the video. Any questions, we'll send you a thank you note, obviously. And those who couldn't also, because we had over 200 who registered, by the way. So we will go ahead and provide our emails. Again, please ask, because we're an added resource. We care for our industry, and we're here to serve you. Okay. So
and one last note.
right.
we're going to be submitting this program for credit, possibly for CAM, possibly for board member. We're going to see what the division will give us. So we will let you know if that happens. We have the list of attendees, and hopefully people can then get some continuing education credit for this as well. I see there's still questions coming in. Email them to me. Unfortunately, we're out of time. I'm very grateful, and I will do my best to answer your questions. Just be a little bit patient with me, but I'm very grateful you all were here and participated, and for all the very kind notes that I saw in there. I'm really very appreciative. I love talking about these topics. Intellectually, I really love what I do, and I had a lot of fun doing it. So thanks again.
Thank you, everyone. Have a great day. Thanks, Ryan.